Hi, this is Chapter 9 Hearsay, Chapter 9 lecture video, Hearsay. You should have already read the chapter, should have the PowerPoint pulled up and your textbook in front of you. Let's look first at the myths and facts about hearsay on page 244 of your textbook. Myth: a person cannot be convicted based on hearsay. Fact: a conviction can be based on any type of admissible evidence, even hearsay. Myth: hearsay only applies to what people say. Fact: hearsay applies to oral and written statements. Myth: hearsay only applies to what other people say. Fact: hearsay applies to what everybody says when they are not under oath. Myth: things that defendants in a criminal case say are not hearsay. Fact: what the defendant says outside of court is hearsay, but there is an exception to the hearsay rule that makes these statements admissible. Myth: most states have done away with hearsay rule. Fact: most states have expanded the exceptions to the hearsay rule so that more hearsay can be used in court. Slide 5. Hearsay defined. Hearsay is an out-of-court statement made by the declarant and being offered to show the content of the statement is true. A statement can be oral, written, recorded, even body language. The declarant is the party who made the statement in the past, and it falls under the federal rules of evidence. And on page 246 of your textbook, it gives the definition of hearsay. Rather, 245. Slide 6, hearsay rule and admissibility. The hearsay rule states that hearsay is not admissible in and of itself. Why hearsay is not admissible? Because the party could lie about the content or the recollection, what they can remember. The party testifying could misinterpret what was said. The defendant loses right of cross-examination by the declarant, the person saying it. But there are many exceptions to this rule, and the federal rules of evidence lists 30 exceptions. The textbook only covers the most common. It doesn't cover all 30. Page 247 of your textbook. Let's look some more at this because it can be confusing, so we want to break it down. The hearsay rule is very simple, even though it doesn't seem like it. Hearsay is not admissible in court. There are exceptions to the rule. Statements are admissible in court if they fall under one or more exceptions of the hearsay rule. Many hearsay statements were admitted in the Drew Peterson case. He's the one that killed his wives, drowned them in the bathtub, and claimed it was an accident. There are several reasons for the hearsay rule. The most important is a basic distrust of testimony that was not made under oath. Giving false statements while under oath can be prosecuted as perjury. Since the hearsay statement was made without any fear of prosecution for perjury, it's not considered as trustworthy as statements that are made under oath in court. Another reason courts are suspicious of hearsay is that the jury did not see the person while they're making the statement. The fact that the person who originally made the statement is not testifying at trial also means the defense attorney can't cross-examine them. Toward the bottom, the Confrontation Clause of the Sixth Amendment to the U.S. gives the defense in a criminal trial the right to confront someone who's accusing that person. All the way at the bottom, last paragraph, despite the fact that there are very good arguments for not admitting hearsay into evidence, there are some situations in which out-of-court statements should be used. These statements are the basis for the exceptions to the hearsay rule. And they are based on the source that the statement was trustworthy, such as an example of a trustworthy statement would be a dying declaration of a murder victim. And that's typically believed by our society that if someone is dying, what they say, their last words, are the truth. And that's generally believed in our society. Slide 7, testimonial hearsay. Testimony offered to the police or courts in prior cases is hearsay and is inadmissible. Only if statements are made informally to assist law enforcement can they evade being hearsay. 911 tapes are not testimonial hearsay. Slide 8, Crawford versus Washington. Mr. Crawford was on trial for assaulting Mr. Lee for trying to rape Mrs. Crawford. Crawford argued self-defense, claiming that Lee had a knife. When interviewed by the police, Mrs. Crawford stated there was no knife. The statement to the police was testimonial hearsay and inadmissible against Mr. Crawford. That's an example. Slide 9, declarant unavailable. The person who made the statement is unavailable. Testimonial evidence. Past testimony may be admissible if the party again testifies. Unavailable declarant. There are several exceptions exist if the declarant is now unavailable. Page 250 of your textbook. Unavailability, second paragraph, is a requirement under 3 hearsay exceptions discussed in this chapter. Declarant against interest, dying declaration, and former testimony. And actually, let's look at the top paragraph of page 250. Several exceptions to the hearsay rule are based on the declarant being an unavailable witness. If the declarant is alive, the attorney who wants to introduce the statement is expected to conduct a thorough search for that witness and subpoena him or her. This is referred to as exercising due diligence. The judge will not declare a witness unavailable if it appears the side wants to introduce the hearsay evidence, the side that wants to introduce the hearsay failed to do so because of diligence to find the declarant. Down in the middle of page 250, you can read this yourself. Reasons why a person whose hearsay is sought at trial may be declared unavailable. You can see the reasons why somebody would be declared unavailable. Back to slide 9. Federal Rules of Evidence 804, that actually defines the unavailable witness as described on page 250. Just a quick list. Exempted because of privilege. We'll talk about privileged communications later in this textbook. Witnesses refuse a court order to testify, a lack of memory, unavailable because of death, mental illness, or infirmity, absent and unable to locate. Let's look at slide 13, admissions and confessions. An admission of a party and used at trial against them, federal rules state this is not hearsay. Most states claim it is hearsay but grant exception for admissions. Practical application, a confession, there's an agreed statement. It's made by an agent with authority. Slide 14, admissions by co-conspirators. Some states allow this exception. A statement must be made as part of the conspiracy. Let's look at page 253. Admissions of a party. You should read that on your own. Admission of a party. Read that paragraph on page 253. But let's look at examples that are and are not admissible on page 253. And let's see here. You can read that on your own too. So all of page 253 you should read again. Slide 15, declarations made against an interest declarant unavailable. Under Federal Rules of Evidence 804, the statement made against pecuniary interest, statement subjects party to a civil or criminal penalty, render a claim made by a declarant invalid. Page 257 of your textbook. Let's see here. And there's the Federal Rules of Evidence 804 that you can read there. We already mentioned co-conspirators. Let's go ahead and look at page 254, adoptive admission. That applies when one person accepts a statement made by someone else. Bottom of that paragraph, this form of admission is based on the assumption that the statement was true because an innocent person would immediately deny a statement if it were untrue. Bottom of the next paragraph, a person does not need to do anything that obvious. Failing to respond to the statement is considered admission. Walking away without saying anything is considered a tactic admission. Let's look at page 255, admission by co-conspirator. Many states have a hearsay exception for admissions by co-conspirators. This rule closely mirrors the criminal law rule that makes each co-conspirator responsible for acts of other conspirators. Statements made by one conspirator during the conspiracy can be used against other conspirators. The statement must be made within the scope of the conspiracy and in furtherance of the purpose of the conspiracy.